I'd appreciate it if you wouldn't mention that wealthy thing to the dean. I'm going to talk about one particular aspect of this kind of litigation, sort of a narrow sliver that spills over into other areas, and it's the use of contingent fee lawyer arrangements by municipalities and states to pursue public nuisance litigation. On the one hand, this seems like a brilliant idea. The fact that the state can bring in private attorneys who can operate on a contingent fee arrangement. If the state loses, they lose nothing. If they win, they pay attorney's fees, but there seems to be no harm done, except to the system and except perhaps to the Constitution. It's my position that while I certainly understand and can sympathize with the desires of states to use this form of legal representation, I believe that it's unethical, politically problematic, and may well be unconstitutional. Basically, what we're doing here is starting up a dangerous mixture of private incentives and state power. And to understand the structural problem with this, I think we need to start off by looking at the division of state power and private action in a democratic constitutional system. We have a state action requirement. With the exception of the 13th Amendment, which prohibits slavery, there's no part of the Constitution that regulates private behavior. The reason for that is, in a liberal democracy, we've decided to try to foster individual development and individual growth without putting on the individual the kinds of restraints that we put on the government. The government exercises public power. The government can do good and it can do harm, and that is why we put constitutional restraints on the government. When the government brings in private attorneys who are incentivized by the desire to win for the purpose of being paid, we have undermined the appropriate role of the state in its relationship to its citizenry. Let me start off with a premise and then try to spin logically from it. Imagine a system where a U.S. attorney is paid more for obtaining a conviction than an acquittal. I have no doubt that that system would be deemed, at the very least, unethical. As the United States Supreme Court said in a very famous case, Berger versus United States in 1935, the United States attorney is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. So I think it would be universally conceded that an incentivization through payment system for a U.S. attorney to obtain a conviction would be considered an improper mixing of private incentives and pursuit of the public interest. Well, if we start out with that premise, let's see how far we can take it logically. I think it's reasonable to infer from that premise that the same would hold true for a representative of the government suing in a coercive civil action, meaning where the state is the plaintiff. The relationship between the prosecutor or the government attorney and the defendant may not be identical in a civil case and a criminal case, but we still protect property rights as well as liberty rights, and the state action limits of the Constitution apply when the government is acting in a civil capacity as well as in a criminal capacity. So therefore, it would be inappropriate for a government attorney to be paid more when he or she is victorious, even in a coercive civil action, than when they were not victorious. The reason in both cases is that we want the attorney representing the government to focus on the interests of the public, not on their own narrow private interests. This is the paradoxical concept that in my writing I've referred to as adversarial neutrality. We don't expect an attorney for a party to a case, whether it's the government or a private individual, to be neutral the way we expect an adjudicator to be. Of course, I would never even suggest anything to the contrary. The fact remains, when an attorney is representing the public, it is their role to pursue the public interest, not to focus on the naked concerns of victory. Sometimes an acquittal serves the public interest more than a conviction. Sometimes declining to even file a prosecution or a civil action furthers the public interest rather than the active, aggressive pursuit of it. We want those decisions to be based not on some private incentives of the attorneys involved, but rather on the basis of the attorney's good faith assessment of what the public interest is. To color it by saying you will get paid if you are victorious in this action, but get nothing if you're not, is to distort public power with the kind of private incentives we expect from private litigants, but do not expect from government action. Okay, that's my premise and my first spin out from it. Well, what can we spin out from that? Can the state avoid the ethical problems that confront it when it has private incentives, financial incentives for attorneys that don't normally apply when the state is pursuing an action? Can they avoid those problems by delegating that state power of representing the interests of the public to private attorneys? Well, it's basically Constitutional Law 101 that the state action doctrine would preclude them from circumventing the limitations on what they can do by delegating a public function to a private authority. One can think back to the post-Brown versus Board of Education situation where states in the South tried to circumvent the restrictions of Brown by creating private schools that were funded by the state. Every case that dealt with it threw those out because they claimed these were delegations of state power. Just as when state prisons use private contractors to provide either control or care, those officials are controlled by the 14th Amendment because they are exercising state power. The same then applies when the state decides to farm out its own litigation to private attorneys. The private attorneys are not acting as private individuals. They are treated for purposes of ethical requirements and for purposes of the Constitution as if they were government attorneys. Since I believe I've already established that government attorneys cannot get incentivized by contingent fees, it logically follows that neither can private attorneys. Now, I've talked to some of my politically conservative colleagues about this, and they have very mixed feelings. On the one hand, anything that restricts the state is okay with them. On the other hand, they don't believe there is such a thing as the public interest. They would rather have individuals focus on their own private interests than try to develop some concept of an elusive public interest. And there is a debate in American political theory as to whether there is a concept of the public interest separate from the private interests of individuals. I don't feel I have to get into that debate. Whether one conceptualizes the public interest as something apart from the sum total of all private interests, the one thing it isn't is the particular private interest of an attorney. there has to be something beyond narrow incentivization of for profit-making purposes of an attorney that guides the determinations of an individual exercising state power. Now, I have raised the question of whether this practice would be deemed unconstitutional as well as unethical. And of course, the consequences are potentially enormous if the due process clause is in fact violated here. I recognize it's a frontier issue, it's a controversial position, but at least as a thought experiment, I believe there's a serious argument can be raised that the due process clause is violated. Again, let's start with a premise and see what we can spin out from it. There is no doubt that a judge cannot be paid more for a conviction than for an acquittal. The Supreme Court established this in 1927 in Toomey versus Ohio, and note that they had nothing turn on whether in the individual case there was a showing that the judge had done anything improper. It was the very appearance of the impropriety, the very subtle existence of the improper influence on the judge's decision-making, even if the judge, him or herself, didn't recognize it, that was what violated the notion of a neutral adjudicator required by the Due Process Clause. Okay, to spin out to the next level is a little more difficult than my previous logical inferences, I think. Can we say that a prosecutor or a government attorney in a civil case is limited by due process the same way an adjudicator is? Well, again, we're dealing with a very different situation. Of course, we can't expect neutrality from the adjudicator. But this is where my concept, my paradoxical concept of adversarial neutrality comes into play. Yes, the government attorney is an adversary. Yes, the government attorney is operating within the adversary system as an advocate. The fact remains that because of the public interest with which they are imbued, they have to focus on the broader concerns beyond the narrow, immediate interests of their client and look out for the interests of the system and the society as a whole. Is that dictated by the Constitution? Well, there's one Supreme Court case, Marshall versus Jericho in 1980, where the court basically intimates as much. In a civil action, they suggested, it was dictum, but that a government attorney cannot have direct financial incentives involved in the case, and raised that to a constitutional level. One might say, well, we have a judge, we have a jury, why can't they look out for the public interest without having the government attorney be so focused on it? Well, we have a system of tripwires. Basically, we have different levels of protection. If a judge is acting improperly in a case, we don't say, but that's okay because we have an impartial jury. If there's impropriety on the jury, we don't say, well, that's okay because we have a neutral judge. We require all levels of governmental power to be acting in good faith towards its private citizens. Again, we can't expect the government attorney to be acting with the same impartiality as judge or jury, but we do expect them to look beyond the narrow interests of themselves as well as the narrow adversary interests of their client. In this sense, they are required to obey the social contract that implicitly exists between private individual and government. Well, if this is true, and I recognize it's a big if, but if this is true for purposes of government attorneys, again, delegating it to private attorneys makes them no different for purposes of the Due Process Clause and the 14th Amendment. Basically, it comes down to this. When state power is being exercised, when the power and authority of the state is being brought to bear, that is when we expect concerns that go beyond the immediate interests of the attorney and the immediate interests of the client. We need those who represent the public interest to focus on the public interest. Thank you very much.